Welcome into the Rocc Pod, presented by the Royal Oak, Michigan Chamber of Commerce. I am John Gay from Jagged Detroit Podcasts.
I am Lisa Bibby, your neighborhood realtor with Keller Williams Advantage.
And we have a great guest and an important topic today. It might not be a topic that you are jumping in to learn about, but it is so critically important, and we have an expert with us. We have Howard Collens from Galloway and Collens. Welcome to the show.
Glad to be here. Thanks for having me.
So let's start from the beginning, Howard. How did you end up starting the firm? Like a little bit of your professional background and how you ended up heading out on your own.
Yeah. So my law partner is Scott Galloway, and Scott and I, interestingly enough, met during law school. We were doing a clerkship together. He was there for a summer. I was there for a little bit longer than that. And then our paths separated. He was at Indiana University and I was in school in Detroit at U of D. We saw each other at the bar exam. Our paths separated. And then I took a job and ended up at a spot at the UAW Legal Services Plan in Taylor, and he was working there.
Huh.
And we worked together there for about 7 years before we opened our firm. So we circled the map and we walked up and down Woodward and found an office space that would work for two attorneys who were leaving a legal services plan with no clients. And we started out 20 years ago this January that we began our venture. And literally we had no clients, 3 computers, 2 attorneys, and off we went.
Happy anniversary, by the way.
Yeah, thank you.
Yeah, happy anniversary. So Howard, I want to kind of just start with the basics here, because as a realtor, we deal with this on almost every transaction basis. And there's a lot of times when clients get into a real estate transaction and they don't have the proper documents. So you can avoid all of these mishaps by talking to someone like you and getting these prepared beforehand. So let's start with estate planning basics and who needs what documents, things like wills, trusts, and powers of attorney.
Sure. The great majority of people don't have any written planning, which leads to some unexpected problems. You know, none of us know if or when we will grow incapacitated. We all know we'll die, but none of us know the when.
Right.
And so we'll all probably need some kind of documents to help us along if we want to make things go more smoothly. If a person doesn't do any written planning, there'll still be methods for having certain transactions happen or managing their affairs or even making decisions for them. But if they choose to have a smoother path, having written documents, of estate planning documents, would be a critical life step, right? I often get clients in who are younger, who are so excited because they're like, we're becoming adults by signing our estate plans, right? And not like they intend to die anytime soon, and hopefully they won't. But
well, people don't realize like estate planning isn't about making things easy for you. It's about helping your family out and knowing how they should distribute funds, properties, and things like that. So it makes their world easier. And again, we never know when we're going to go or, like you said, become incapacitated where we can't make those cognitive decisions. So having these documents in place is really all about helping your family.
that's exactly right.
So back to Lisa's question, how do I know if I need a will versus a trust or a power of attorney? Like who gets what?
Sure. I would say that pretty well anyone could find good use of a financial power of attorney, a medical power of attorney, a standalone HIPAA release. I have clients who are just turning 18 and going off to college and setting those documents up because they're now adults. And if something were to happen, their parents want to still be able to help them out. But if there's nothing in place, those challenges will be really complicated. So having a financial power of attorney, a medical power of attorney, what's called a patient advocate in Michigan, or a standalone HIPAA release will be a critical base set of documents. Now, from there, it's probably also important to consider whether you should have a will or a trust or both. And, you know, some of that's technical, right? So the most basic setup, say a last will and testament would be useful. In Michigan, we have what's called the laws of intestate succession, which describes how your estate passes if you have assets in your name only when you die and don't have anything in writing. So it's a specific law that calls out who takes what out of your estate. And the idea behind the intestate laws are that they're intended to pass things the way most people will want them to pass, right? And so if a person is comfortable with the intestate distribution, maybe it's not necessary to have a will or a trust. Some people I have come into my office, they designate beneficiaries on their assets and they have financial power of attorney and it's all good. And that could be, that's a very basic setup, but that might be sufficient. Now, that's not for everyone. More sophisticated estates will require a will, but then a will, if you have a will, guarantees probate on your death if you have assets in your name alone. And we can talk about that more in depth if you like to. But having a trust may be an entirely appropriate way to hold assets during your lifetime, allow for their administration upon incapacity, provide a means for distribution of those assets after the death has occurred.
Trust can also be very useful. I know a lot of people who own multiple properties, there's a number of ways they can distribute that and protect themselves by either putting them into an LLC or putting them into a trust.
Absolutely. Having a trust gives real flexibility, right? One of the prime advantages of having a revocable trust, revocable meaning it be canceled or amended, changed, having that kind of vehicle, a trust to manage assets, allows for a lot of flexibility upon incapacity and provides a really good mechanism for distribution processes after a person passes, including real estate. One of the great uses of trusts we employ is if people have property in Michigan, let's say their main house is here in Michigan, and then they have a real estate that's out of state somewhere. Having no written planning means that they're probably going to end up having 2 estates to administer in 2 different states. Having those same kinds of assets in a trust means that they can have their family receive those assets with only one administration usually. It's a lot simpler in ways. That's one of the benefits of having a trust, right? It avoids probate at death in a lot of cases.
So you had just mentioned probates. And again, if you don't have a trust or a will in place and you die, your property and all of your assets have to go through probate. So can you talk to us a little bit more about this and, contested, and let's talk about estates and guardianships and conservatorships as well.
Sure. So probate court serves as a forum for helping people who can't do things for themselves. If you think about a person who has grown incapacitated and hasn't done proper written planning, like what we talked about already, if that person needs medical decisions made for them, they can't do it themselves. If they have bills to pay and they're incapacitated, they can't do it for themselves. So the probate court serves as a forum for people to approach in those kind of situations to set up a guardian to make welfare decisions for a person, medical decisions, where they're living, their general welfare issues, right? That's the guardianship side. The conservatorship side is dealing with financial affairs of a person who's grown incapacitated and who doesn't have proper planning in place. So managing their finances, whether it's bill paying, whether it's selling assets or buying assets. It could be a business owner who's not done effective planning and they have a business that has to be run. The conservator might be charged with running the business.
Wow.
Or at least managing that process, even if they're not running the business themselves. But the conservatorship and the guardianship, those are probate court involvements for a person who is alive but incapacitated. The other element of probate that people think about a lot is after a person dies. Right. So if a person's deceased, then there has to be an orderly way to manage that person's estate because they're dead. They can't sign the deed over.
Right.
They need to have someone who can manage stuff, gather those assets together that the person who died left in their name only, and then go through the whole process of marshaling those assets, identifying creditors, dealing with creditors if they're valid ones, dealing with the last tax returns, and then making the distribution, whether that's the intestate distribution that we talked about or a distribution under a will. And that probate process is something that a lot of people have the desire to avoid, which I think is not a bad notion. I also think it's perhaps overly scary to people. That's unnecessary. One of the things I would say about probate in courts in general, frankly, I can say this as a lawyer who shows up in court on a regular basis. They are our courts. We should be walking into them to see what they're like. And I'm talking to people who might be listening to this podcast to say, you should show up to your local court to see what goes on. It's worth figuring out because the law that happens or the justice that happens there is our justice. We should be seeing it.
So it sounds like more important than a date night, we need to have a date to the court and sit in there and find out exactly what's going on.
Well, and I think that's such a good point, Howard, because, there's the stereotype, if I'm going to court, it means I'm in trouble, whether it's anything from a speeding ticket to something worse. But getting in there, you can sit there and you can see how the process works more than, say, your 9th grade civics class. I love that idea.
And most, at least in the probate realm, most cases are uncontested. It's just administration.
Mm-hmm.
And if you think about it, the way that a decedent estate works in most instances, there are never hearings. You're never in front of a judge. Most probate administration happens with the proper filing of the proper papers at the right time to the probate registrar's office, whether that's by mail or fax or email. It's process, but it's not court in the way of, a judge sitting in a robe on a bench with a gavel. By the way, they never use a gavel. I mean, that's a dirty little secret, but that's true.
Yeah. But that's the goal for people to get these documents in place to avoid that probate court, as we call it, completely.
No, for sure. And many of my clients will say that one of their goals is avoidance of probate.
Mm-hmm.
Now, if they have a trust-focused estate plan, then they might accomplish that goal. But it is not without some effort on the front end after the trust is set up, because it's important if you set up a trust to deal with the proper funding of it, making sure that the assets that are owned are titled in a way that will flow through the document in a way that avoids probate. Okay, let me break that down if I can.
Sure.
So if you think about a trust, when you start it, when you sign it, it's a contract. It's a pile of paper with words on it, right? Now, they matter, and I don't mean to diminish it, and they're quite lengthy oftentimes, but the words matter on it. And what happens in the document is that the trust describes that it holds assets that are titled to the trust, and then those assets are managed by the trustee. If the assets are placed into the trust, it's an empty bucket when it starts, but then those assets can be placed into the trust in the name of the trust. And if that's been done properly, then that can be used to avoid probate. What ends up happening, unfortunately, in some situations is that people don't do the legwork. They sign a trust, which is that empty bucket, and then they put it in the drawer and they never do anything. They never go to the bank and say, hey, bank, we have a trust now. We want to make sure that our bank account flows through the trust, either right now or as a beneficiary when we die. If they don't go through those steps and people have set up a trust, then those assets may very well end up in probate. Those assets will be in the deceased person's name alone when they die. And that requires a probate process. Now, the properly set up trust will also have a will, and that's called a pour over will. That will catches those assets that are in the deceased person's name and then pours them over into the trust.
So you're saying there's more to pour over than just coffee. Got it.
But it's a bad result because it's two administrations, a probate administration in the first instance, dumping into the trust, and then the trust administration in the second. It's a fail-safe, but it's not the way it should be done in an ideal world. So when we set these trusts up, we really spend some time talking about funding the trust, making sure that the assets are properly titled into the trust, either right away, eventually, or not at all. And then making sure that when those assets do get placed in, that the legwork is done by going to the bank, by making sure the deed is right. Those are critical steps, and people often overlook them or ignore them, and they do so at their peril.
Makes sense. You mentioned all these things about preparing and getting all your stuff in line. You also said you've been in business for 20 years now. I've got to imagine in 2003, digital assets were not nearly as significant and important as they are in 2023. Can you talk a little bit about granting somebody fiduciary access to your digital assets, whether that's passwords, online accounts? Like, that has got to be such a big thing for you right now.
Sure. So if you think about it, America Online started business 40 years ago.
Oh my God. Oh, I feel old.
Don't tell me you're still using that.
They did their internet service like 10 years after that. So in the, let's call it the mid 90s, right?
Yep.
Early mid 90s. You've got mail, right?
USDD.
Exactly, right?
And an AOL Instant Messenger username. Yep.
If you think about what that means, though, that means that there is a whole generation of people who are used to digital assets.
Yeah.
What's a digital asset? It's everything from your email to your online banking, not the money in the bank, but how you get to learn about it, right? The access. It is your social media. Depending on where we store this podcast, it might be this podcast.
Sure.
Right? Because if you have this stored on a digital drive up in the cloud somewhere, that's a digital asset.
Right.
So the question is, what would happen if you grow incapacitated or you die and you're holding these kind of assets? How do you get to them? And so what the problem is that the law, like so many times, is behind the times.
I see that in podcasting too. The law when it comes to ownership of podcasts has not kept pace with the technology.
Right. And so fortunately, we're making some progress in this area. A few years back, I helped get a law passed in Michigan called the Fiduciary Access to Digital Assets Act.
Thank you.
And it took some time to get it to happen. There was some real pushback by what are called the digital custodians. Think Google, AOL, Yahoo. They were not happy about the idea of this going into place. And so the first run at it didn't work. They were too strong, and the solution that was proposed wasn't the right one to get passed legislatively. The second go round is what's now in place. So it's been a part of the law for a few years now.
What does the law entail? What does it provide for?
So what it says is that different kinds of fiduciaries have different kinds of access to digital assets. If you think about the general concept, those who plan will be rewarded and those who don't will be punished. That's the general concept. So if you have a written plan that specifically calls this out, you will get better access than the person who doesn't have any written planning. So that's nebulous. Let's talk about what that really means. So think about an email. And an email under this law has two components, the catalog and the content. The catalog is the to, the from, the when. So it's interesting, but it's not like the good stuff, right? The good stuff is the content.
You want the message.
The subject line, it's the body of the email. So if a person hasn't done any written planning, the best that their fiduciary is going to get is the catalog. Now, if they've done written planning that calls this out to say you get both catalog and content, then the fiduciary will get both. I forgot to define an important term. What's a fiduciary?
It's the person who you're putting in charge, right?
Exactly. It could be your agent on your financial power of attorney. It could be your trustee of your trust. It could be your personal representative. That's the technical term, what people often refer to as executor of a will. It could be your conservator or a guardian, right? And if you think about the conservator sort of context, that person hasn't done effective written planning. So the best the conservator in most cases is going to get to is the catalog. They're not going to get the good stuff. So it incentivizes written planning. Now, if a person did an estate planning, 10 years ago, this wasn't part of the law.
Right.
So that plan is insufficient for the purposes of dealing with digital assets. Estate plans represent moments in time, right? We can plan for what we know right now and what we think we can think about a few years into the future. But the law is always changing. So the plans have to be adjusted. And people's lives are always changing too, right? I mean,
for sure.
People come into your life, people go out of your life in a variety of ways, whether it's a birth, a death, a marriage, a divorce. Those kinds of events cause plans that need to be changed. But the change in the law is also a significant event and could mean that the plan that you thought was great in the past is less great today.
Howard, we spent a lot of time talking about the why for estate planning. It's probably a good time to ask you about the how. If we walk into your office, how does the whole process work?
Sure. The way we approach our estate planning cases is we work on an hourly basis. So I charge an hourly rate. We have an associate attorney who does work on the case. That person charges their reduced rate. There's a paralegal who does drafting work. That person bills their rate. And there are some attorneys that are out there that will charge a flat rate. I don't find that that's a good approach personally because it makes the attorney guess. And I think most attorneys guess high.
Oh, yeah, that's true.
I like to find myself on the same side as the client. I want to be efficient, and I think we are. And I want to make sure that we cover things in a full, complete sort of way because not every case is the same. And I'll say this, most people think they have a simple plan, which is lovely, but it's usually not true. Because when you start thinking about how complicated this stuff is and the questions that have to get answered and figured out, it is not simple. It is not simple because things are complicated.
So what is your hourly rate? And, is it something that somebody can come in and sit down with you for like an hour, 2 hours, if it's not a complicated situation?
My hourly rate bill's at $400 an hour. I discount my time for chamber members. So if you're coming to me through the Royal Oak Chamber and you're a chamber member, say that. I want to make sure that we discount our time for fellow chamber members. I think that's important.
Underscore that gold star red pen. Make sure we make a note of that. Absolutely.
Yeah.
So you mentioned the Royal Oak Chamber, Howard. How has being a part of the Royal Oak Chamber benefited you and your firm?
Well, it's been instrumental. We started humbly and needed to grow a business. And so we thought it was really important to be active in the community. And what better way to be active in the community than through the local chamber? Our local chamber is unique, I think, in that it is entirely community-based, focused on business and supporting the local businesses that build our community. So because that is the focus of the Royal Oak Chamber, it was important for us to participate. I mean, we got involved because we want to meet people, because our business is about people. It's true whether it's the estate side that we've talked about or whether it's the real estate work that we do in our firm, which is a significant part of our practice. But that is a people-focused practice. And so what better way to meet other people that have it together than through the chamber?
So Howard, we've talked a lot about your business, and we'd love to know, what are you doing for fun when you are not helping people with all of their estate planning needs?
So probably the best thing that I can tell you that I do for fun is I play trombone in a klezmer band.
Ooh.
What is that?
What is it, trombone or a klezmer band?
No, we're familiar with trombones.
I think we're good on trombone.
All right. Yeah. So those not familiar, it's a brass instrument. So a klezmer band, we are a group that gets together and plays, it's Eastern European Jewish music, but we also play Balkan and Roma music.
Oh, wow.
So the one that probably most people are familiar with are like things like Hava Nagila, right? But
sure.
I mean, that's just a very popular example, but there's all sorts of music. I mean, some of it's quite contemporary, so it's towards jazz, and some of it's more traditional.
Does your band have a name?
We do. It's called Gesundheit.
Gesundheit. Oh,
That's
love
brilliant.
it.
So as somebody of Eastern European Jewish descent, I feel bad now that I did not know what that was on first reference. I feel like my ancestors would be very disappointed in me.
So we play all the time. Actually, we've played previously at Art Beats Needs.
Oh, that's cool.
We play regular gigs, through the community. It's a lot of fun.
On one stage, you've got Howard, and on one stage, you've got Whitesnake. It's unbelievable.
I love it with Gesundheit. So now it is time for our fishbowl question of the day, where we ask you a completely random question. So John, do you want to pull that question for us?
All right. Let's see what we got here randomly, Howard. All right. I'm not really sure how this one got into our hat to draw. It's kind of a random question, but here goes. Real simple, Howard. Pancakes or waffles?
Oh, that one's easy. Pancakes.
Why?
They're flat and delicious.
But the waffle has the little pockets to catch all the syrup.
That's overrated, I think.
Do you have a favorite kind of pancake?
I really like banana.
Hugh Jack Johnson, banana pancakes. There we go.
There we go.
Howard, we appreciate you coming in and sharing a few laughs with us today on a topic that can otherwise be pretty serious.
Oh, yeah, for sure. I mean, doing an estate plan can be a mental challenge because it's thinking about death and dying. But if you approach an estate plan with some lightheartedness and some humor, it can be a process that is certainly manageable.
If somebody wants to come find you at the firm, what are the best ways to find you?
Sure. Our website is GallowayCollens.com. We are on all sorts of social media, so you can follow us on Instagram. We have a Facebook page. You can call us. We have an old-fashioned phone, 248-545-2500. You can stop in at our office if you choose to. We have good snacks.
And by the way, if you grew up on AOL, the telephone is the thing that is a hidden function on your iPhone or your Android that you may not use that often, just so you know.
Oh, that's right.
Oh my gosh. It was so great to have you on today, Howard. Thank you. My name is Lisa Bibby, and I'm a realtor with KW Advantage. I put the real back in realtor. If you're looking to get your house sold before all the competition, give me a call for a free consultation. You can find me on Facebook, YouTube, and Instagram at Sold by Lisa B.
And I am John Gay from Jag in Detroit Podcast. If you are interested in a podcast for your business in 2023, or you have any questions at all about the world of podcasting, I am your guy. You can find me on my website, jagindetroit.com, or you can find me on social media at jagindetroit. The Rocc Pod is produced for the Royal Oak Chamber of Commerce. We thank you for listening to it today. And if you want to know more about the Royal Oak Chamber, you can find them online, royaloakchamber.com. Thanks, everyone.